NIOS welcomes you all in this video for subject Political Science. Code is 317, module number 3, Structure of Government, lesson number 12. Topic is Supreme Court of India. For senior secondary. Difficult words. First we will do difficult words. After that we will read the chapter. First, court. कोर्ट का मतलब होता है ऐसे डिपार्टमेंट्स या ऐसे संस्थान जहाँ लड़ाई झगड़े या क्रिमिनल केसेस होते हैं उनको सुलझाया जाता है और उनका निपटारा किया जाता है। साथ ही साथ जो क्रिमिनल केसेस होते हैं उसमें किसको पनिशमेंट मिलेगी और फाइन लगेगा ये भी कोर्ट डिसाइड करता है। कॉलेजियम, कॉलेजियम में बहुत सारे जजेस होते हैं जिनका काम होता है कि वो कोर्ट के जो हाई जजेस होते हैं वो मिलकर एक कॉलेजियम बनाते हैं और वही सारी चीज़ों को डिसाइड करते हैं। ओरिजिनल ज्यूरिडिक्शन। ओरिजिनल ज्यूरिडिक्शन का मतलब क्या होता है? फॉर एग्जाम्पल कि किसी लैंड को लेकर डिस्प्यूट हो जाता है और हम कोर्ट में वो केस फाइल करते हैं और वो उस केस को हम बोलते हैं ओरिजिनल ज्यूरिडिक्शन। अपीलेट ज्यूरिसडिक्शन। कोर्ट ऑफ रिकॉर्ड्स। जब कोई केस खत्म हो जाता है, उस केस के फिनिश हो जाने के बाद उसके रिकॉर्ड्स को, उसके फाइल्स को, डॉक्यूमेंट्स को और जितने प्रूफ्स हैं उन सबको संभाल के रखा जाता है, उसे हम बोलते हैं कोर्ट ऑफ रिकॉर्ड्स। अगर किसी केस की पुरानी इंफॉर्मेशन देखनी होती है, जाननी होती है, तो हम कोर्ट ऑफ रिकॉर्ड्स में वो सारी इंफॉर्मेशन रहती हैं। नेक्स्ट वर्ड है प्रोटेक्शन। जो कानून होता है लोगों को उनकी प्रोटेक्शन का राइट देता है, सुरक्षित रहने का। गार्डियन ऑफ द कॉन्स्टिट्यूशन। नेक्स्ट वर्ड है सिविल केस एंड क्रिमिनल केस। सिविल केस में आ जाती है घरेलू हिंसा, डिवोर्स, मारपीट, आर्ग्यूमेंट जैसे केसेस जिसमें कुछ सीवियर पनिशमेंट नहीं दी जाती बट फाइन देकर छोड़ दिया जाता है। बट क्रिमिनल केसेस में सज़ा काफ़ी सीवियर हो सकती है, लाइफ टाइम इम्प्रिजनमेंट हो सकता है, डेथ पेनल्टी हो सकती है या कोई मोटा अमाउंट एज अ पनिशमेंट दी जा सकती है। ये दोनों डिफरेंट है। नेक्स्ट वर्ड है जुरिडिक्शल रिव्यू। judicial review, public interest litigation, PIL, judicial activism, now we will do objectives. Recognize that India has a single, integrated and unified judicial system. Describe the composition and organization of the Supreme Court of India. Explain the powers and jurisdiction of the Supreme Court of India. Appreciate the role of the Supreme Court of India as guardian of the Constitution. And protector of fundamental rights. Single, unified and integrated judicial system. The distinct features of our judiciary is that it is a single, unified, integrated judiciary system for the whole country. A single judiciary represents a hierarchy of courts. The Supreme Court stands at the top of the single integrated judicial system with high courts at the state level. Below the high courts, there are several subordinate courts such as the district courts, which deals with the civil case, and the session courts, which decides criminal cases. As you see in the picture, India judicial system, Supreme Court, first Supreme Court of India, then state high courts, and then subordinate courts of lower courts. At last, subordinate courts or lower courts. Supreme Court. Supreme Court is the highest judicial authority of India. It consists of the Chief Justice and 25 other judges. The Parliament may increase the numbers of judges if it deems necessary. Besides the Chief Justice, there were only 7 other judges. The Parliament has increased the numbers of judges from time to time. As in 2005, there are 25 judges beside the Chief Justice, who is also called the Chief Justice of India. The Chief Justice and other judges of the Supreme Court are appointed by the President of India. While appointing the Chief Justice, the President is constitutionally required to consult such other judges of the Supreme Court as he deems proper, but outgoing Chief Justice is always consulted. Normally, the senior most judge of the Supreme Court is appointed as the Chief Justice of India, although there is no constitutional requirement to do so. While appointing other judges, the President is bound to consult the Chief Justice and other senior judge if it deems. Whenever there is vacancy or a likely vacancy in the Supreme Court, the Chief Justice and 4 other senior most judges considered various names and recommended the names of the person to be appointed as judge of the Supreme Court. This system is based on a ruling of the Constitutional Bench of a Supreme Court headed down in 1993 and reinforced in 1999. Thus, while the Constitution still provides that the President is the appointing authority of the Supreme Court judges, the ruling of the Supreme Court has since 1999 become virtually binding on the President. The power of selection of judges has passed on to a group of Supreme Court judges called the Collegium of the Court. The power of selection. The President now performs the formality of appointing the nominee of the Supreme Court after the Law Ministry formally recommends these names to him.
जीवन ये प्रकाशित करने राहों को आलोकित करने हम अपना दीपक स्वयं बने, हम अपना रास्ता स्वयं चुने। हम
अपना दीपक स्वयं बने, हम अपना रास्ता स्वयं चुने।
जीवन ये प्रकाशित करने राहों को आलोकित करने
धन साधन समय की सीमा से विद्यालय जो मुक्त हो,
धन साधन समय की सीमा से विद्यालय जो मुक्त हो।
कभी पढ़े हम कहीं पढ़े वे विषय की लोच से युक्त हो।
कभी पढ़े हम कहीं पढ़े वे विषय की लोच से युक्त हो।
मित्रों जीवन ये प्रकाशित करने, राहों को आलोकित करने।
राष्ट्रीय मुक्त विद्यालय का है द्वार खुला सबकी खातिर।
शिक्षा परीक्षा का अवसर एक बार ही क्यों मिलता फिर।
शिक्षा परीक्षा का अवसर एक बार ही क्यों मिलता फिर। दुनिया में इसके केंद्र बहुत,
कोई मन चाहा केंद्र चुने, हम अपना जीवन स्वयं बने, हम अपना रास्ता स्वयं चुने। कोई मन चाहा केंद्र चुने, स्वयं बने, हम
Let's continue with qualifications. A person is qualified for appointment as a judge only. He, she is a citizen of India and also he and she fulfills one of the following conditions. He or she has been for at least 5 years a judge of as a high court or two or more than two such courts. And he, she has been for at least 10 years an advocate of a high court or of two or more than two such courts. Or she, he is in the opinion of the President a distinguished jurist. Tenure. The Chief Justice of India and other judges of the Supreme Court hold office till they attain the age of 65 years. A judge may voluntarily resign before expiry of his term. In exceptional cases, a Supreme Court judge may be removed before the age of retirement, according to the procedure laid down in the Constitution. A judge of Supreme Court can be removed from office by an order of the President passed after an address by each house of the Parliament supported by the majority of total membership of the House and not less than 2/3 majority of the members of the House, President, present and voting, passed in the same session, has been presented to the President for such removal on the ground of proved misbehavior or capacity. Removal of judges in India. So far, proceedings for removal were initiated only in one case against a judge of the Supreme Court. But she or he could not be removed because the resolution could not be passed by the Parliament. It is clear that Supreme Court judges enjoy security of tenure and the executive cannot arbitrarily remove them. No person who has held office of a judge of the Supreme Court is allowed to plead as an advocate in any court or before any authority within the territory of India. Supreme Court judge cannot be a lawyer for anyone. The judge of Supreme Court are paid such salaries as are determined by the Parliament from time to time. Court of Record. The Supreme Court is a court of record. It has two implications. All its decisions and judgments are cited as precedents in all courts of the country. They have the force of law and are binding on all lower courts and indeed the High Court. As a court of record, the Supreme Court can even send a person to jail who may have committed contempt of the court. Jurisdiction of the Supreme Court. The scope of powers of Supreme Court to hear and decide cases is called its jurisdiction. The Supreme Court has three types of jurisdiction, namely original, appellate, and advisory. First, original jurisdiction. There are certain cases which fall within the exclusive jurisdiction of the Supreme Court. It means that all such cases begin or originated in the Supreme Court only. It also means that such cases cannot be initiated in any other court. The case or dispute that come under the original jurisdictions are given below. A. Disputes between the Government of India on the one side and one or more states on the other side. Disputes between the Government of India and one or more states on one side and one or more state on the other side. Disputes between two or more states The Supreme Court has been invested with special powers in the enforcement of fundamental rights. In this connection, it has the power to issue directions or writs. Third point, cases under public interest litigation (PIL) can also be heard directly. This is an extra constitutional practice. There is no mention of PIL in the Constitution.
प्रकाशित करने, राहों को आलोकित करने। हम अपना दीपक स्वयं बने, हम अपना रास्ता स्वयं चुने।
अपना दीपक स्वयं बने, हम अपना रास्ता स्वयं चुने।
जीवन ये प्रकाशित करने, राहों को आलोकित करने।
धन साधन समय की सीमा से विद्यालय जो मुक्त हो,
धन साधन समय की सीमा से विद्यालय जो मुक्त हो।
कभी पढ़े हम कहीं पढ़े, वे विषय की लोच से युक्त हो।
कभी पढ़े हम कहीं पढ़े, वे विषय की लोच से युक्त हो।
मित्रों हम उठे और जागे,
मंजिल आने की ध्वनि सुने। हम अपना दीपक स्वयं बने, हम अपना रास्ता स्वयं चुने।
जीवन ये प्रकाशित करने, राहों को आलोकित करने।
राष्ट्रीय मुक्त विद्यालय का है द्वार खुला सबकी खातिर।
शिक्षा परीक्षा का अवसर एक बार ही क्यों मिलता फिर।
शिक्षा और परीक्षा का अवसर एक बार ही क्यों मिलता फिर। दुनिया में इसके केंद्र बाटे,
कोई मन चाहा केंद्र चुने। हम अपना दीपक स्वयं बने, हम अपना रास्ता स्वयं चुने। कोई मन चाहा केंद्र चुने। स्वयं बने, हम
Welcome back. Now let's continue. Appellated jurisdiction. It means the power of a superior higher court to hear and decide appeals against the judgment of a lower court is called appellate jurisdiction. The Supreme Court has vast appellate jurisdiction. It hears appeals against the judgments of the high courts. It is the highest and the final court of appeal. If one of the parties to a dispute is not satisfied with the decision of the High Court, one can go to the Supreme Court and file an appeal. The appeal can be filed in civil, criminal and constitutional cases. Appeal in civil cases, disputes relating to property, marriage, money, contract and services, etc. are called civil cases. If a civil case involves a substantial point of law of public importance needing interpretation of the Constitution or law, an appeal against the High Court decision can be made to Supreme Court. Earlier, the financial limit of the civil case was ₹20,000, but now, according to the 30th Amendment of 1972, there is no minimum amount for taking a civil appeal to the Supreme Court. If substantial question of interpretation of law or constitution is involved, appeal may be made against the decision of the High Court. Appeal in criminal cases. An appeal may be brought to the Supreme Court against a High Court decision in a criminal case in a number of situations. Firstly, if High Court sets aside an appeal or an order to acquittal passed by a lower court and award death sentence to the accused, he may bring an appeal to the Supreme Court by right. Next, appeals in criminal cases. Secondly, appeals can also be made to the Supreme Court if the High Court withdraws a case from the lower court to itself, declares the accused guilty and awards death sentence. For example, Nirbhaya case in Delhi. In this situation also appeals can be made as a matter of right and without certificate from the High Court. The appeal in cases other than these two categories may also be brought to the Supreme Court. Cases related to violation of fundamental rights and PIL can be directly appealed in the Supreme Court or High Court. Court provided the High Court grants a certificate that the case is fit for appeal in the Supreme Court. Appeals in constitutional cases. A constitutional case is neither a civil dispute nor concerning a crime. Case related to writs which involve violation of fundamental rights. For example, Keshav Nanda Bharti case where basic structure of constitution cannot be changed was defined. It is a case arising out of different interpretation of constitution, mainly regarding the fundamental rights. In such constitutional cases, an appeal can be taken to the Supreme Court only if a High Court certifies that the matter in dispute involves a substantial question of law. If the High Court denies the certificate of fitness to appeal to the Supreme Court can use its discretion and grants special leave to appeal to itself in any case it deems fit. Advisory jurisdiction. This power implies courts' rights to give advice if sought. Under advisory jurisdiction, the President of India may refer any question of law or public importance to the Supreme Court for its advice. But the Supreme Court is not bound to give advice. In case the advice or the opinion of the Supreme Court is sent to the President, he may or may not accept it. The advice of the court is not binding on the President. So far, whenever the court has given its advice, the President has always accepted it. The court refused to give its advice on the question whenever a temple existed at the spot when Babri Masjid was built at Ayodhya. This is the end of this chapter. Thank you for watching me.